Howdy, I'm attorney Rick Davis. I'm the founder of Rick Davis and Associates, a law firm in Bryan, Texas. Today I'd like to talk to you about the difference between a personal recognizance bond in a criminal case and a cash surety bond. Now, if a defendant is arrested, he has to be brought before a magistrate within a certain period of time and advised of his rights and be offered the opportunity to request a court-appointed attorney if he cannot hire one, and bond should also be set. Sometimes a magistrate will set what's called a personal recognizance bond. Sometimes the magistrate will set what is called a cash/surety bond. If a cash surety bond is set in the case, what it means is, let's say it's a DWI case and the cash surety bond is set at $2,000. The defendant could post $2,000 of his own money with the district clerk's office to secure his release, and so he would be free on bond based on cash that he provided. On the other hand, some folks can't come up with 2,000 cash just like that. So they might secure the services of a bondsman. Well, the way the bondsmen work is they charge a premium, typically 10% of the total bond amount, and the defendant pays the bondsman that amount. So that would be the defendant in that situation would pay $200 to the bondsman, and then the bondsman is putting up $2,000 in collateral with the county and tying it up and essentially telling the county, well, if this defendant does not appear in court, well, I'm good for the $2,000. Bondsmen are governed by the local bail bond boards. In fact, when I was a district judge, I was on the Brazos County Bail Bond Board. So the bail bond board evaluates the bondsmen to see if they have sufficient collateral, how many bonds they can write, or what's the total dollar amount of bonds that they can write. Because if they have tied up all of their collateral with by posting cash surety bonds, well, then they can't write anymore until another bond is released. A bond is released when a criminal case is ended. Now, there are occasions where if a person doesn't comply with the bondsman's rules, like doesn't report weekly or whatever they ask them to do, or if the defendant gets picked up on another offense, the bondsman might file what's called an affidavit of surrender of surety. So in that circumstance, if the defendant's incarcerated on a new case, well, and then on the older case, the bondsman surrenders the bond, the defendant might find himself in a situation where he has to post bond on the new case and he has to repost bond on the older case. Now, a personal recognizance bond, on the other hand, is one where the defendant doesn't have to actually pay any money at all. If a magistrate sets a defendant's bond at $2,000 personal recognizance, the defendant would simply sign a piece of paper and he's released on his own recognizance. In other words, he's telling the court and the judge, I'm good for the $2,000. I'm going to appear in court, but if I don't, I understand that I will owe the county $2,000. Now, if a person posts a cash bond, they will get that back at the end of the case, provided that they have faithfully appeared at all court hearings. It doesn't matter if they're guilty or not, if they're acquitted or not, if they're sent to prison or sent to jail or given probation. It doesn't matter. Whether you get your bond back depends only on whether or not you faithfully appear in court for all court hearings. So a person could be guilty of aggravated assault, deadly weapon, and sent to prison for 15 years. And if he posted a cash bond, as long as he appeared in court, he would get that money back, even though he was found guilty of that offense. So that's essentially the difference between a cash surety bond and a personal recognizance bond. So for more information, please come see us at attorneyrickdavis.com.